Oops. Okay, good morning, everybody. I hope it's a great week. Let's hear good news this week. The Shiloh that we were dealing with last week, the last thing that we looked at, we just started discussing this. If a person that I need to take to court is not from, am I allowed to take him, or under what circumstances am I allowed to go to secular court? And so the general rule is that you have to still send him a summons to Beis Din. If he refuses to appear, the Beis Din gives you a release and grants you permission. But the first course of action, according to this, cannot be that you just take him to secular court knowing that he won't go to Beis Din. There could be some exceptions to that rule, but he basically says in the footnote, and I just want to start the footnote again, he says, V'chein pasak maran b'shulchan aruch. U'makor leheter hanal, the source of this permissibility to go to secular court is based on, the Rosh writes, is on the Gemara in Bava Kama, is based on the pasuk, Karisa chavercha v'lo ancha, ramiguda rabba shadibe. That your friend, your friend summoned you, you summoned your friend and he did not respond. Rami Guda Rabba Shadibe. That I think it means that you can, I guess, place a great wall on top of him. Vizel and what he says is as follows: Mikan pasuk Rav Paltoi Zal. That from here Rav Paltoi paskind. Reuven sheyesh lo tvia al Shimon u'masariv lavo imo ledin. That Reuven has a claim against Shimon. Shimon refuses to come to court. You're allowed to go to Gentile court in order to extract the money from him. In other words, the story in Bava Kama was the rabbi said, you summoned your friend, he didn't come, now you can throw a wall on him. In other words, give him the full force of the secular court. And this is the halacha. He says the only problem about this is the harei bahalich le'arkos ovrim alav shel lifneihem velo lifnei akum. We learned last week that it's based on a pasuk. Ve'ele hamishpatim asher tasim lifneihem. These are the laws that you shall place in front of them, which teaches me you can only bring a law in front of Jewish judges, not in front of Gentile judges. V'harambam kasav shehu iser chamer biyoser. Ad shekasaf al misha aso. The Rambam writes that this is such a serious offense, taking someone to a secular court, so that he, to the point where he writes that harezer rasha uchilu chereif v'gidev v'hirim yad b'toras Moshe Rabbeinu. That it's to the point where anyone who goes to secular court is a wicked person. And it's as if he blasphemed against God and lifted up a hand against the Torah of Moshe Rabbeinu. Kemuval lamala b'divrei Rabbeinu shlita, as was quoted above. V'im kein tzarich iyun, eich mutar la'avor al ha'isser hanal b'shvil harvachat mamon. How then is a person allowed to go to secular court if it's just a matter of making money, o kedei shelo lahafsid mamon, to prevent a financial loss? Isn't there a law that even if it's going to cost you everything you own, you can't violate a negative commandment of the Torah? So we see that this question was asked already in the Sefer Kli Chemda. The Teretz, the Chol ha'isr lelechas le'arkos umishum dichsiv lifneihem velo lifnei arkos. He says, and his answer is that the Torah says, place it in front of the judges, the Jewish judges, not in front of the Gentiles. But here, where it's simply not possible for you to place it in front of the Jewish judges because your counterclaimant refuses to go, leka isser Torah, there's no longer a prohibition. So it seems like the lichora midivrehem yotze chidush ledina, He writes in the brackets, he says, it would seem like there's something that we can extract from this. He says, the imyeshne Yehudim garim b'makom she'ein shum ofen li'itdayen b'fnei beistin yemuter ladun be'erkos. That if two Jews live in a place where it's simply not possible for them to go to beistin, let's say they live out in Yehupovsville, right, and there's no way to get a rabbi out there, there's no way to get some adjudicator, some arbitrator, some rabbi to come and arbitrate the case, then they can go to court if it's not feasible. But he says, Vitzarchi, and it's not so clear. Shuv matzanu shekain kasav hagrach palaji zatzal b'sifra chukos chayim diek came divrei harivash v'poskim kiyuyin sham. But he says, but that's in the truth. The Sephardi posek Rav Chaim Palaji actually paskins that way. Ubeir dekiven she'i efshir klal adun b'dinei Yisrael. He says, in a situation where it's not feasible for them to get a Beis-Din to judge them, Memela ein et ha'isor shelifneihem ve'lo lifnei akum chedivrei haklichem. There's no longer the prohibition of bringing a case before Gentile judges. V'chein mashma b'shut divrei chayim ayin sham. And he says, and this seems to be the implication of another sefer that he quotes. He says, and don't ask the question based on what the Ramah says. Ayarot shein bahem chachamim haruim liot dayanim, o shekulan amei haaretz. The Ramah writes that if you live in a place where the shtetl doesn't have any talmidei chachamim, right? Utzrichim lahem dayanim sheyishbetu beineihem, shelo yelchu lifnei erkaot shalov dekochavim. And he says, and they need judges so that they don't have to go to a secular court. Mimanim hatoivim v'hachachamim shebahem l'dat anshei ha'ir. What you should do is, even though the people in the city are not Talmidei Chachamim, find the smartest people you can get in that community. In other words, even though by their own admission, they're not completely experts in halacha, but if it's all you got to use the best that you got. Even if they're not really worthy to be dayanim, the kaven shekiblu aleim b'nei ha'ir ein acher yachol poslan ad kan l'shana. And once, the members of the community accept them, no one can declare them to be puzzled because they're not qualified. It seems like from the Ramah that any community that you live in, you should be able to adjudicate your differences based on finding Jews to preside over a case. He says, it could be that the other poskim who say that you are allowed to go to erkaot when you can't find a Beis-Din is talking about where you live really out in the sticks, where you can't even find, let's say you can't even get a minyan, right? Or basically there's just like this Chabad house that serves barely a minyan of people and they're not Shomer Torah and mitzvahs. So in a situation like that, maybe you have your heter, you can immediately go to court. But if you, well, he's not a tribunal. Maybe the argument would be is that you need to have a tribunal. But to get the Chabad rabbi, maybe. But it's a great question. You should be able to preside over it as long as the two parties are amenable to it. There are some technical laws that the two litigants have to be standing in front of the judges so that they can see them and that they can discern their facial expressions and things like that. I believe that there are probably already tshuvas that exist that permit standing before judges by a video conference. Yeah. It's a good question. He says, so now this is this is what we had started speaking about on Friday. He says, Amnam kol ze shaykh be'erkaot shel goyim, aval tzarich liyantu v'yim ha'eter anal shenifsak b'shulchan aruch shayach bizmanenu. He says, but that was all in the times of the, when we were talking about going to a secular Gentile court. But what about if you live in Eretz Yisrael And what heter would there be? Litvoa acher be'erkaot sheb'medinat Yisrael shahashoftim sham Yehudim. He says, so you live in Israel. Your contractor really messed you up royally, okay? Which, surprise, surprise, that would never happen, right? And all of a sudden, you have a court case against your contractor, okay? And so you want to take him. He says, there's no way I'm going. I don't believe in that stuff. I'm not going to a bunch of guys with beards. You want to sue me? Sue me. I'll see you in court. So the problem is that the judges in an Israeli secular court are Jewish. So he says, the Yesh Lomar the Chulmashu Hutar B'Shulchan Aruch Litvoa Ilaim Be'erkaot, Anu Davka Be'erkaot Shel Goyim. The fact that you have a heter in the Shulchan Aruch that when a person refuses to go to Beis Din with you, you can go to Erkaot, you can go to secular court. That's only when the secular court is comprised of Gentiles. Avalim Tovo Be'erkaot Shashoptim Yehudim, Arei Bazeh Machshilam Ladun Shlo Kfiat Torah Belichora Over Belifnei Iver. So he says you are causing the judges, the Israeli Jewish judges of the court, to judge according to an outcome that is not necessarily according to the laws of the Torah. So by you standing before those judges, you're actually causing them to sin. Ve'ein heter shel hefsid mamon ki adarabba nifsak b'shulchan aruch tzarich adam levater al kol mamano kadei shelo lavar al yisrael l'chana. He says, and don't tell me, well, I'm going to lose money if I don't do this. He says, there's no heter to cause someone else to sin just because you're going to lose money. It says, Lifnei iver lo titein michshol. You may not place a stumbling block in front of a blind person. If these judges, we look at these, that's how we say, we should look at these judges as fellow Jews. By asking them to adjudicate my case, I am in essence asking them to govern the halacha or govern the outcome of this conflict based on secular law and not based on Torah law. How am I allowed to do that? They did, but what heter do I have to get them to do that? In other words, you could make that argument anytime. A guy is a professional wine taster for non-kosher wine, and he happens to be Jewish. What heter do I have to get him to taste a particular wine? Just because he put himself in that position, but I don't have a right to cause him to sin further. Yeah, so further sin. V'shuv matzanu shekein katav lahedja hagon Rabbi Yecheskel Sarna, and Rabbi Yecheskel Sarna was a posek in the early 20th century in Eretz Yisrael. He said the same thing. He said it disturbed him how he said the last line he said, "V'kasha linso heter lazeh." It's very hard to find a heter to how we can allow two Israeli Jews to go to secular court because of the fact that these judges are being prompted thereby to violate the halacha. So that's where we were up to last time. So he says, "V'ra'inu b'sefer divrei Mordechai shekatavnu shapam omar harishon letzion hagon Rav Mordechai Eliyahu zatzal b'shir de b'sar v'yesh la'atil alecha lebeit mishpat." He says there's a sefer that quotes Rav Mordechai Eliyahu, who was the chief Sephardic rabbi. We're going to see a lot of Sephardic poskim in this sefer because it's written by a Sephardi posek.
According to Torah law, secular state of Israel, let's call it that, really has no legal binding. Especially if the judges.
Well, we didn't say it doesn't have any legal. It's really what you're asking is a somewhat different shaila.
Yeah.
The shaila is does the law of Dina de Malchuta Dina apply in Eretz Yisrael? And we actually, when we were learning Imrei Yaakov, we actually raised that question, and we saw that there's a dispute among the poskim. whether Dina de Malchuta Dina applies in Eretz Yisrael. But it sort of touches this discussion as well, because but here he's being more localized, and he's basically saying every time I cause a judge to rule on a case, not according to Torah law, but rather according to Israeli law, I'm causing him to sin. So, because he's not ruling according to Jewish law. I don't know. That's a good question. Yeah. Well, you could also make the argument that even a Beis Din many times will rule according to secular law. And so that could certainly obviate this discussion. Is that, in other words, a Beis Din is obligated according to rule according to Dina de Malchus Dina. So if the outcome of this conflict if this outcome would be the same if they went to Beis Din as it would be if they went to secular Israeli court, so then what would be the difference? So let's see what he says. He says, Rav Mordechai Eliyahu once paskin that if a fellow Israeli refuses to go to a Beis Din, you can go to the regular Beit Mishpat, you can go to the regular Israeli court. The Siper Shapam Echad Torah Kein Lo Ma'aseh. He says, and he related that he once paskin that way. Ubai Lav Hagon Rabbi Yecheskel Sarna Zatzal Va'amar Lo Sheheter Zeh Shel HaShulchan Aruch Lo Shaych B'Beit Mishpat Shovtim Sham Yehudim. Right, and he says, and Rav Mordechai Eliyahu reported that Rav Sarna once came to him and said, "How can you do that? That heter to go to secular court only applies in Chutz La'aretz, where the judges are Gentiles. It doesn't apply in Eretz Yisrael." Va'analo harav Mordechai Eliyahu v'chich vodo rotzeh she'eshlach oto lebeit mishpat Palestinai. So he said, so what's the alternative? You want me to send him to a Palestinian court in Gaza? Okay. And it was on that basis that Rav Eliyahu said it's okay for him to go to an Israeli court. V'tamua ma'od, demat shuva heishav al tainas agri sarna, sheyesh kan iser chamor shel haramat yad b'torat Moshe Rabbeinu, the iser lifnei iver v'cholich Moshe kasafti leil. But he says, I don't really understand what Rav Mordechai Eliyahu's response was. In other words, yes, so you're right. There is no alternative to take him to an Arab court. But in other words, so like, what kind of response? Sharia, yeah. I'm sure it's similar. Okay. Now he quotes from a sefer called Kovetz Yeshurun, Shehevi Hagri Zilberstein, as Divrei Hagri Sarna Zatzal, Shalosh Shayach Heter Halich Le'erkos Keshashoftim Yehud. He says Rav Zilberstein concurs with Rav Sarna that the heter of going to Erkos does not apply when the judges are Jewish. Because of B'Shem Hagrish Al Yashiv Zatzal Yashiv Al Pi Abir Hagra Sheheter Lalecha Le'erkot Keshanitva Ilaim Al Pi Hagemara Begitin. He says, and Rav Yashiv explained the whole heter to go to Erkaot, to go to secular court, when the counterclaimant is refusing, is based on a Gemara in Gittin. Shahanachrim chovtim va'omrim asay mashi Yisrael omrim lecha v'chulei. That the Gentiles will come down with force and basically say to you to do what the Jews tell you to do. In other words, let me just make sure that I'm explaining that Gemara correctly, but it's let's look up the Gemara really quickly. We said it's Gittin Peiches, Gittin. Okay. Get Me'usa Yisrael kosher v'agoyim pasul. With regard to bill of divorce that the husband was compelled by the court to write and give his wife, if he was compelled by a Jewish court, the get is valid. But if he was compelled by Gentiles, it is invalid. But with regard to Gentiles, they may beat him at the request of the Jewish court and say to him, do what the Jews are telling you, and it is a valid divorce. Okay, that's the case that he's quoting over here. And basically, he says v'im kain, and that's the basis for going to a secular court, is because they're basically going to coerce you to do the same thing that the outcome would have been in a beis din. V'im kain ze shaykh gam beveit mishpat shehashoftim Yehudim shehabeitim omrim lahem asu kefi dinei Torah ad kan devarav. He says, and the same thing would be true if you go to a secular court that's comprised of Jewish judges, where the court would tell you to do according to the rules of the Torah. V'lo zachinu lahavin, but I still don't understand. She'ikar mekor zeh shehevi hagon kvar muva bebeis Yosef sham b'shem bal hatrumos, shal pizeh hitr lelechas le'erkos keshabal din ilaim v'abeitim yichtu hu adracht al mechasav. He says, if you go to a secular court and the secular court basically places a lien on your property as the source of collection of their ruling, in other words, if you go to beis din and the beis din paskins, Ruvain sues Shimon in beis din, Shimon loses the case. The beis din basically says, we now place a lien on Shimon's property. Reuven can collect from Shimon's property what Shimon owes to Reuven. Reuven can now take that piece of paper that says that he has rights of collection from Shimon's property and even take him to secular court, because all the court is doing is upholding the ruling of the beis din. That's the classic case. Einhem poskim et adin kodem lachein, shazi yeh efshel liton kenal dahabi kenachem chovtim varmim asem ashi Yisrael omrim lacha. He says, but when we tell a person you have a heter to go to secular court, it's not that the beis din is ruling in favor of one of the litigants and saying, based on our ruling, you can go and get your collection from the secular court. The beis din is basically saying, we don't know who's right and wrong. But if one of the litigants refuses to go to beis din, so go to secular court. So shayachim kan tainus agri sarna zatzal. So you still have the same argument of Reb Sarna, that what heter is there, because you don't know whether the outcome in the secular court is going to be the same as what it would have been in the beis din. And we know that there are a number of other Sfarim who raise this concern. So basically, he says at the very end, he says, the argument that he wants to bring is Kaven shahatovea tova tchila beveitin kefi din Torah, arehu mar'eh bazeh she'eno miyaker dinei ha'arkaot v'rakdan sham bal korcha. He says the person who wants to go to beis din but his counterclaimant refuses, by sending him a summons initially to go to beis din, he's demonstrating that he would rather go to beis din, and therefore he should not be held blameworthy if the other party refuses. Uvenosaf l'chol hanal yesh lahosif tim kol shomrei haTorah yakpidu shelo lodin klal beveit hamishpat yeitzei michshol harbe yoter garua shebezanadam miyad l'chol adam lahazik misha shomer Torah biyado shelo yichalu tovo achar kach bedin. And furthermore, we also have to make it clear that if we make a policy that people can't go to secular court in Israel, there'll be terrible damage, right? Because what'll happen is that people will take advantage of religious Jews. and with the knowledge that, well, he's a frum Jew, he won't be able to take me to secular court. So we can't allow that. So basically his conclusion is that even though it is problematic, he acknowledges that it is more problematic in Eretz Yisrael than in Chutz La'aretz to go to secular court. He says, but there really is no other option. First of all, if you really want to go to Beis Din and the other fellow doesn't want to go, so you are demonstrating that you want to do the right thing, even though you may be causing other people to sin. He says, but they are already mumarim. It's almost like what Paul was suggesting, that they've put themselves in that position to say that they don't consider this anything wrong, and therefore you're not in violation of the Isser of aiding a person to do a sin, because you no longer are responsible for that person's behavior. And second of all, he says, from a public policy, we can't say to people that you can't go to secular court, that frum Jews can't go to secular court in Israel, because that'll create a tremendous michshol that anyone who's frum will, it'll become common knowledge that they're not going to go to secular court, and people will take advantage of frum Jews. Okay, let's go back up to the top. He says now, "V'ha'isur lalechel erkot shel goyim hu mideoraita, delav haba michlal asay dino ka'asay." He says, because now we know that this is a biblical prohibition to go to secular court. Basically, because it's based on the Torah's commandment, these are the laws that you shall place before them, the Jewish judges. And so once the Torah says that, it's a mitzvahs asay, that you must go to secular court. Because of hadivrei emes, sha'af al pisha harambam lamana isser ze b'minyana mitzvot. He says, now why does the Rambam, however, does not count that as one of the 613 commandments? So why not? Hainu mishum she'ein derech harambam limanot lav haba michlal asay. He says the Rambam has his reasons on a technical basis as to why he doesn't count this as one of the 613 mitzvos, but it is this particular sefer holds that it is deoraisa, not like another sefer called Mekor Baruch, who argues that it's only derabanan. Uvesefer chukos hachayim ichmir ma'od ba'onsho shel ha'olech le'erkaot shel goyim. Rav Chaim Palagi was very strong in his language of saying how really wrong it is to go to a secular court because of hatashbeitz dim adam kibel kesef al pi psake erkaot neged dinei toratenu hakdosha v'kidesh bazai isha ena mekudeshes. The Tashbeitz writes, who's 18th century, he says that if a person was awarded money by a court, by a secular court, that they ruled in such a way that it was against what a Beis Din would rule, and he goes ahead and he uses that money to present a woman with kiddushin, she's not mekudeshes, because that money is stolen money. And he also writes that if a Jew and a Gentile have a financial conflict, and the goy is willing to go to a Beis Din, you're not allowed to take him to secular court. That God does not do this for any other nation and does not inform them of his laws. So basically, you see that God even includes Gentiles in the category of the laws of the Jews, just that they don't have their own laws, but they're subject to the same laws. So essentially, let's say a goy has a very good Jewish friend, and the Jewish friend says, you know, I know you have this financial conflict with this guy that's in my community, but you should know that if you go to a Beis Din, you'll get a better outcome, since the requirements, the evidentiary requirements in a Beis Din are much higher than the evidentiary requirements in a secular court. So according to the Tashbates, the Goy can say to the Jew, what right do you have to take me to secular court? You should take me to Beis Din. I remember about 20 years ago, there was a story in the Wall Street Journal about a hotel chain in Arizona that they were sued by a frum Jew. And the frum Jew suggested that they go to Beis Din that could save a lot of money in court fees. And they went. And they reported in the Wall Street Journal article how pleased this hotel chain was with the professionalism of the Beis Din. So it didn't record it. Didn't record it. Like, I think it was like, no, they basically, like, each party got something, I think. Anyway, we'll hold it here for today. We'll continue Mirza Hashem this discussion.
Right.
No, it's still good.
It's not a yes or a no.
Yeah, even when you know that the